Yeah.
Well, the video's not as good this time, but oh, you're coming in. Okay. Greetings, Richard Gabriel.
Greetings, Ted Donner.
I have not seen your mug in so long, but yeah. Anyway, good to see you.
Good to see
So
you.
we are Skype recording. This is kind of cool.
Yes,
I and I appreciate you doing this again. Thank you very much. You are right now eventually going to be sitting on a screen in a room full of a bunch of law students talking about this Peter Liang case and about trial consulting generally. So I'm going to ask you some questions if that's all right.
sure.
Um, I, you as a trial consultant work with trial teams to coordinate strategies for what the theme is going to be for the case, how witnesses are going to be examined, how the evidence is going to be presented, and how the jury selected, that kind of thing, correct?
That is absolutely correct, among
Can you
a
tell
variety of other things.
can you tell us a little bit about your process and how you work?
Well, our process has changed a lot over the years. And, I think one of the things that I think we've evolved to in our practice here is that we understand that the story that is detailed in both the evidence and the law is not the same as the story that the jury processes. So what I think we endeavor to do here is, as we're going through the documents and talking with the attorneys, is identify, just from a jury's perspective and quite frankly from a human perspective, what are the elements that are going to affect their decision making in the case? Not just what the evidence is, not just what the law is going to pertain to it, but what are the various psychological factors? What are their predispositions? What are their biases? What are their assumptions about the evidence and the facts and the substantive matter that they're going to be listening to? And then what is the ultimate story that they're going to be getting from either side, from both the prosecution side or the defense side, or the plaintiff side and the defense side in a civil case? That all then goes into we're trying to understand what is the primary narrative that we want the jury to essentially assimilate and then use to convince other jurors in the case that our side should prevail. How can we control, how can we frame, how can we dominate essentially that narrative? And then obviously who are the right people for that? So for that, we're trying to understand what the evidence and law is, but we're also trying to understand what's between the lines. In other words, what are the fundamental issues? For example, in the Peter Liang case, obviously, what greatly informs a jury's decision-making in this process is all the aspects of Ferguson and Black Lives Matter and their experience with police officers and everything they've seen on the news, and how they feel about law enforcement, how they feel about different sections of any city that they live in. And so, these are all the background issues that absolutely critically inform their decision process that we want to understand. And that's a lot about what we do, is try to understand, from a jury's perspective, what is going to be their decision. So we're trying to forecast a decision-making process. And then for that, we're then trying to construct a narrative, obviously congruent with both the facts and the law in the case, that then fits into the easiest narrative that the jury can understand.
Let me peel that back a little bit. You mentioned in the Liang case this idea of people's exposure to Ferguson, for example, and the Black Lives Matter movement and how that informs their decision making.
Yeah.
You've got a room full of 30 or 40 prospective jurors, and they all say, why, yes, I've heard of Ferguson. Yes, I've heard of Black Lives Matter. What does that tell you?
Well, that by itself doesn't tell you anything. What you then have to do is carefully construct questions in the jury selection process that endeavors to dig into how they feel about these issues. So to do that, you ask questions that are designed to understand attitudes that the juror has that they themselves may not even know they have. and to me, this is really where the art is of jury selection, because jury selection is sometimes we sort of presuppose, okay, we're going to ask questions to find out how jurors feel about issues, but sometimes they don't even know how they feel about stuff until we engage them in a meaningful conversation about those issues. So in the Peter Liang case, they may not have a fully formed sort of cognizable, not cognizable, understandable. That's not the word, but it's they may not even know themselves really what their attitudes are. So part of the process is in a non-judgmental way, asking them questions that are actually fairly simple, like, well, what is your feeling about how the police operate in inner cities these days? You know, what do you see as the role of law enforcement? How do you think that law enforcement deals with different ethnic groups? These are the types of questions that are not easy questions to ask or to answer, but they ask the jury to dig into their own consciousness and to try and figure out for themselves, well, how do I really feel about this? So that by itself can produce a more meaningful dialogue about these issues.
In the class, we've talked a little bit about the ways in which jurors tend to respond to questions which are focused on their aspirational beliefs versus their own experience and what they've been through. And I've tried to focus them a little bit more on experience than beliefs, because as law students, they tend to go, well, I think the rule should be this, and I think the rule should be that. And so I guess I want to talk a little bit about the dichotomies you sometimes see between people's aspirations and their own experiences and things, and how that can affect those kinds of answers.
Well, the easiest entrance point in any of this dialogue really has to do with personal experience. So sometimes, obviously, it's a more difficult, it's a more meaningful conversation, I think, to talk about actual attitudes and beliefs. But in the process of getting jurors to open up, the easiest way to do that is to have a discussion with them about who here has had a negative experience with law enforcement. And then the follow-up question to that is, what was that like? What happened? What were the kinds of conclusions that you drew from that one experience? And that obviously gives you a launching point to then extrapolate out to larger issues. Well, how do you think law enforcement deals with minorities in general? You know,
Right.
for that. So the experience is really quite critical. But for me, it's a critical leap jumping point to get into really how they think and how they believe, what their beliefs are about law enforcement or these critical issues.
In the course of the mock voir dires we've been doing in class, the students and others have had an array of experiences. You know, we see the the stereotypical Blue Lives Matter type, the stereotypical Black Lives Matter type. People need to behave themselves. If they only listened, the cops wouldn't have these problems. That kind of thing. When you see these stereotypical responses come out of jurors, what does this tell you about them? I know that it matters to you, but what can you learn about them from this?
Well, again, if you stop there, you're not going to learn a lot, because you are going to get sort of, what you want to distinguish is their true feelings from headlines that they've seen. Because if they're just recounting headlines, sometimes when what you're trying to do is recreate deliberations with voir dire. You're trying to recreate a environment where, to a certain extent, you're saying, if you were in the deliberation room, how would you be talking about that issue? And let's say you're hoping to create a dynamic, especially if you're on the defense side, where there's conflict and there's different attitudes towards Blue Lives Matter. There's a Blue Lives Matter contingency and a Black Lives Matter contingency in that deliberation room. Well, they're not just going to keep reciting headlines. They're going to start talking about personal experiences. So to get down to that deeper level, when they talk about, well, I just believe Blue Lives Matter, and you really have to, make sure that we understand how difficult a job that police officers have in doing their job. And what you can do then is say, the easiest question to ask instead of just stopping there is you can say, well, can you tell me a little bit more about that? Or why is that important to you? And they may pause. And the most important thing is when the juror pauses, let them think. We sometimes interrupt their pause and want to jump in and help them out. But the pause is them digging deeper into how they feel about an issue and allowing them to process it a little bit. And then pay attention, obviously, to what they see on the other side. So questions like, tell me what else, how else do you feel about that? What's important about that to you, digs down below the headlines and gets, I think, to a deeper conversation about the issue.
Which helps inform you better who you're dealing with, regardless of whether they serve on the jury or not. It helps you decide who to get rid of, and it decides how to respond to them if they stay.
Right, all right. I mean, the bottom line in all of this, in voir dire, and this is I think, one of the most important points about credibility building for the jury, because this is the first time you as the lawyer get in front of your jury, your audience. And we think of credibility sometimes as resume credibility. A lot of times in the law, we think, well, if I come across as being very authoritative, or I graduated from a fancy law school, or sort of I've done a lot of trials, I've got a lot of experience, that's credibility for a jury. And it's not. Credibility for a jury is how much you pay attention to them. And it's not whether they like you after voir dire, but whether you've made a connection with them. And one of the best ways you can make a connection to a jury and build rapport with them during voir dire is to listen to them. In order to listen to them, you have to really be curious. In other words, as lawyers, and as people in the law, we sometimes sort of jump right ahead to the next thing. I got your answer, I'm moving on to juror number 4, or I've got my next question plan. But when you're really listening to somebody, jurors say really interesting things. It's if you just sit there and say, wow, thank you. That's amazing. Can you tell me a little bit more about that? If you express a true interest, a true curiosity in who they are and how they feel about a subject matter, without judging them, without, trying to correct them, without trying to instruct them necessarily, that to me is where your credibility really gets enhanced. And it's also where you really get to find out about that juror.
That's a good note. You've also talked in the past about the ways in which attorneys should introduce themselves when they're trying to establish credibility. When you're first getting up in front of the crowd, and things you should say to help them appreciate why you're there, why they're there. Can you talk about that just a little bit?
Yeah, I mean, it's, you want to personalize yourself a little bit. And, one of the ways to do that is to talk a little bit about yourself at the very beginning. And just, one of the classic ways that I've seen attorneys do that is, number one, a couple of things. First of all, it's important to acknowledge whatever's going on in the environment around you. If you're in the Bay Area and you're doing voir dire yesterday, you got to talk about how Golden State didn't, came back empty.
Right.
So if you're in Cleveland, you're going to acknowledge, hey, we've got a championship in this city. So you got to always talk a little bit about what's the elephant in the room. And I think that's always important because it acknowledges kind of what everybody's thinking. Here in Los Angeles, it was 110 yesterday. So you talk about the way. So that's an easy way of sort of just going, okay, I'm just like you. I'm experiencing the same kind of phenomena that you, the juror, is. Then I think it's a good idea just to talk a little bit about yourself. And the best way of doing that without making it sound too hokey, but you can say, look, you've had to share as jurors and you're going to be sharing stuff that's personal about you. I thought I would start. Here's who I am. Here, I'm married. I've got 2 kids. and just by opening up a little bit yourself. And even giving an example that I've seen in the past of if this were a case involving, a crime against a child, I just don't know if I could be fair in a case like that. I just have such strong feelings. It brings up too much for me just because of where I'm at with my kids. Things that give you an example, that gives jurors an example. And that's a real good way, I think, of personalizing yourself and creating a model for disclosure, which is really what you want them to do.
Nice, thank you. All right, I want to talk to you. I want to get back into this case just a little bit because there's things about it that we've touched on that I'd like to drill into a little bit further if we can. You talked, for example, about when you're first looking at the thing, trying to get a perspective on what the case is about, what your themes are, what the issues are that are going to be bothering the jury. In this example, you talked about this notion of people being exposed to the Black Lives Matter movement or to what happened in Ferguson. One of the other dynamics that I see in the last couple of classes we've used this case, and just like I saw in Zimmerman, is people are very interested in whether the jurors have involvement with guns. And I've been fascinated by how much that line of questioning tends to come up and the different ways in which people think it is useful to them. And I thought I'd ask you about it. If you know that the jurors have experience with handguns, whether it's being somebody going on Facebook every day to rail against them, or if it's somebody who's got to a concealed carry and is an advocate of NRA, what does that tell you about their likelihood of being a good defense or a good prosecution juror in a case like this?
Well,
or what does it tell you you will need to know, I guess, more importantly?
It can be. I mean, I don't think, in a particular case like this, it's necessarily determinative. And this is one of those issues which if possible, we would love to do a focus group or a mock trial. Obviously, gun debate is very hot in this country right now, post-Orlando. And so it might be a very meaningful conversation. Most of that has to do with personal handgun ownership as opposed to police use of firearms in this country. It's interesting that you'd bring this up. Overall, you want to spend most of your time in voir dire finding out about jurors. However, if I'm working for the prosecution in this case and I want to plant a theme, one of the themes I might do later on is how difficult it is for officers in our country, knowing that handguns and weapons are so present, are so available, that an officer going into a building, and especially a darkened corridor, sometimes never knows if somebody has a weapon. So the availability of weapons to the general population and the fear that an officer could get shot at any time, is perhaps a theme that a prosecution might use because it goes to reasonable use of that weapon and an officer's state of mind, which is really what you're trying to do in any sort of police enforcement case or wrongful death case involving a unnecessary use of force. You're trying to say usually the standard is whether the officer reasonably believed they were in danger at the time. And so
it's something like that here too, yeah.
I'm not sure what the exact wording is, but that's a big component of that. So if I want to plant that theme, maybe gun usage and gun availability might be interesting. I mean, it's one of those questions which I think there's other areas which are much more relevant for this case, and where, especially in a limited time voir dire, attitudes about race, attitudes about law enforcement and minorities, attitudes about law enforcement in different geographic parts of town, all of that, I think, that's the core conversation you want to have, and it has to be a very brave conversation. Because to me, that's going to, even if it doesn't even show up in deliberations, it is going to inform how jurors think about this case when they come into judging whether that officer really reasonably, thought they were in danger at the time. And also, I mean, quite frankly, another area that I think you have to go into is officer training.
Right.
Just in general, how well do you think officers are trained in this? Because, when we do these cases all the time, you have jurors who say, gee whiz, why don't they shoot him in the shoulder? Why don't they shoot him in the leg? Why don't they talk him down? And they don't understand how officers are really trained in deadly use of force. And so that's going to be an educational point that, especially if you're working on the prosecution side, you're going to need to work with. When you're on the defense side here, on the prosecution side, you want people, for the most part, who do think that the police are poorly trained. You want to believe that they're, for the most part, these guys aren't trained well, that they're sort of going off willy-nilly, and that they're sort of rogue renegade things. And to a certain extent, and this is one of those strategy calls, you don't want to uncover some of this bias. You want that to go for the defense side.
To fester, yeah.
So
there was one student, I can't remember who it was, that introduced this idea on the defense side. The prosecution had been talking about, well, let me back up a second. They did some voir dire sampling, and what they were finding was that they had some conflict in the idea of wanting traditional jurors who are law and order focused for the prosecution versus gray jurors who were less law and order focused for the defense, because the defendant is a cop. And that creates this dichotomy of who are we as the prosecution sitting here with a cop as a witness, whose credibility we do want to bolster, versus the defendant who we don't. And so they started talking about doing this from a bad apple style of theme. That, generally speaking, we're all good guys, we all know what we're doing, but this idiot here, he went off the reservation and did what he wasn't supposed to do. The defense, when they tried that strategy, came back with this idea that it's not really him to blame, it's the system. And it is the training that was at fault, and it is the people that are sitting over there that should have been teaching this kid how to do things, that it's their fault. And so those two themes are a little different than what you just suggested, but they just came up with them the other day, and I went, that is interesting. And so I wanted to throw those at you and see what you think, because it was like, I had not thought of it. Kind of reminded me of you and Phil Spector when you called me and said, hi, we're getting jurors who've been sitting here for 6 months instead of people who don't know what they're doing. I was, huh? What did you just say?
Right. It's an interesting theme. This is obviously one of the things we'd like to test out in a focus group or mock trial.
Right. Sure.
And the question for me with that theme is, does that let him off the hook? If you have that theme, or do they say, well, too bad, he's a product of this system. We're not going to let him off the hook for that. He's actually perfect emblematic of this system. So we're going to convict him as a result because we're convicting the system. And that's an important distinction that you want to look at here. And this is, I'm glad we're having this conversation, because you can't do jury selection without understanding exactly what your thematic elements are.
Right. Yeah.
And so if your narrative of this case is going to be from the defense side, hey, he's a rogue guy who's off the reservation, and the defense side of this case is, I was trained this way, and so I'm, this is exactly how I'm trained. And then you need to have a much deeper conversation with jurors about training, about the law enforcement culture that's there, about whether and how they feel about that. And how, whether they feel, and to me, to a certain extent, that does go into even a cultural conversation about guns. What needs to change in culture in order to do it? Because, post Ferguson, some of these things, there's a lot of suggestions about, and quite frankly, there's a lot of law enforcement now that are like I think it's Baltimore now, that is undertaking implicit bias training for their cops. So they're actually
Right.
now studying what are my implicit biases regarding different races, different ethnicities, different religions. And so I understand a little bit more about my biases. And also, you want to have a conversation with them about, well, how well are our cops trained? I mean, there's a big discussion now about how well cops are trained to deal with the mentally ill as
Sure.
a result of shooting. So all of this is a conversation. You're also, I think, taking a look at who are rule followers, because that is going to be the rule following element has to do with whether a juror feels that Peter Liang was following a trained procedure when he drew his weapon and fired it.
Right.
And if they felt that he somehow went outside of his training, then all of a sudden, of course, that's more of a prosecution-leaning juror. But this goes into the training thing, which is sort of an interesting dichotomy, again, with that defense prosecution lean, is if you're saying he's a product of the system from the defense perspective, then you will really want to understand how they're trained, and then you want to understand factually what's the testimony going to be about when he drew his weapon. The other element that you're going to want to talk about here is what you and I talked about yesterday, which is just this chance element, which is that for the most part, he doesn't shoot him directly.
Right.
So
the shot against the wall.
He shot through the wall and it ricochets and hits him. And so it's whether, and this goes to the element of intent, because, is he from the defense perspective, was he in reasonable fear? Did he hear something that said to him, I need to use deadly force at this point? Is there a weapon? So especially when you're dealing with a dark corridor situation, the whole sensory environment becomes critically important, especially from the defense side of the case. From the prosecution side of the case, you don't want to even get into that, because you want to have it believe, from the prosecution standpoint, in a case like this, you want to have the jury believe that he's got all the time in the world, he's got all the information he needs about whether to draw his weapon.
Right.
And for the most part, he draws it irrespective of, that he could have clearly made a choice. And, when you are on the defense side of these cases, especially when it comes time to expert testimony, it's always challenging because everything is broken down into milliseconds. When you break it down in the courtroom, it always feels like that decision-making process is enormous. When in fact, it's snap, I hear something, I draw my weapon and fire. It is a split-second decision that they have to make. So for the most part, again, from the defense side, you're trying to make them aware of how this really happens in real time, not from a slow motion, slow motion replay type of scenario, which, quite frankly, these trials sometimes become about. So this is the kind of discussion that you really have to understand, because if you're going to be doing he broke the rules, then obviously you want then it informs who you choose in terms of if it's a rule following juror or not. Somebody maybe with a military background, somebody who's in a position like an engineer, who has a lot of very strict rules about what they do. A builder or somebody like that. Those kinds of rule following types of thing, type of personalities, as well as things are, the types of people that if you're going to be doing a rule-based theme for your case, those are the types of jurors obviously you're going to look at.
That makes all the sense in the world.
Yeah.
Let me step over to something else that I want to make sure we cover before we're out of time, because we've been going little over 40, if I'm getting this right. And I want to make sure that I don't lose the recording on you.
Sure.
But one of the things that has been fascinating to me about working with you over the years is the perspective you have on the ways jurors deliberate.
Yeah.
Now, Heidi Fleiss is an example that this idea of conflict juries. And I was wondering, can you talk a little bit just in the broad sense of what your thoughts are on those things when you're looking for a jury that is going to work together in a certain way? What your process is and what your thinking is?
Sure, and I'll kind of pose a couple of different cases here. In the Heidi Fleiss case and the Phil Spector case, those are tough fact cases. And for the most part, you want to pick, every individual juror has their own personality. Every group has its own personality too. And so when you're picking a jury, you're picking a group dynamic. And you want to understand when you're selecting the jury what kind of group dynamic you want. From the prosecution side, you need a unanimous jury. And so you need jurors that are going to get along and are going to work well together. When we were doing the Kwame Kilpatrick case in Detroit, I was working for the DOJ. And one of the biggest fears, they had very good evidence in the case, but their concern was that they would have a juror on that case that would just fold their arms and say, he was my mayor. I think he did a lot for the city. I'm not going to convict him. So we needed jurors we had two rating systems. One was for their questionnaire and voir dire responses, but we did a secondary rating, which is how well they would work together with a group of people. And it became important to us because there were some really good jurors that we liked, but we thought that personality-wise, they may not get along with other jurors. So we actually used strikes on some of those jurors. In Phil Spector and in Heidi, we had some bad facts in those cases, so we wanted a high conflict jury. We wanted jurors that would really butt heads, really argue and get into it. And so we chose jurors that really, we thought personality-wise, wouldn't necessarily mesh with other jurors. And in both those cases, we had essentially a hung jury in both of them, even though in Heidi Fleiss's case, they horse traded to get a verdict.
Right. Yeah, that's a story I haven't told anybody in this class. But anyway, maybe I'll have to tell them about that another day.
Yeah.
That's an interesting scenario, that one.
Yeah. Yeah. No.
So I'm just about here. I just wanted to, is there just general things you want to talk to these guys about as attorneys in terms of what they should be mindful of going into the jury selection process to bring us home here?
I think you need to be mindful of your own process and your own biases and your own training. Those are the things that I find are the one thing that gets in the way of truly meaningful voir dire. When I talk about process, the difficulty about jury selection always is that you're trying to design voir dire or jury selection stuff at the same time you are planning your opening statement and your first witnesses. And oftentimes, voir dire gets short shrift. And so the sooner you can really get into planning your opening statement, getting your first witnesses lined up and stuff. So I really think it's critically important that you spend time on that voir dire and don't shunt it off to 2 a.m. the morning before your first jury selection, because that's what you just need to pay attention to that. The second is the training element, which is, for the most part, lawyers are trained to control information. And voir dire is a process of giving up control to the jurors. And so thinking of voir dire is more like deposition, where you're really trying to find out as much as possible, is a much more meaningful model for voir dire. Crafting those open-ended questions, although it's hard as a lawyer, it's so easy to go into the yes-no questions, and you just don't get that rich kind of information that you do. When you get the jurors talking, judges are more likely to give you lengthy voir dire, and absolutely you'll have a much easier time getting the information you need about whether to use a cause, challenge, or a strike. And you're much more likely to avoid a Batson when you're actually, you've got plenty of information that is completely race or gender neutral to make your challenges with. So, for the most part, it's about having this really full, rich conversation with jurors at the outset of the case. And it tells you a lot about, number one, who to pick, but also it establishes a rapport with them and a connection. And it tells you who your audience is. And once you have that information, sometimes then you can reshape your themes and your opening statements based on what's important to those jurors in the box. You can use language that they have given you about what's important to them.
Absolutely. Absolutely.
So those are the things that I would say. If you really do concentrate on those things, you're going to have a much richer experience. I think your jury selection is going to be better, and you'll avoid some of the pitfalls that we sometimes see.
Thank you, Richard Gabriel. Much appreciated.
You're very welcome. On a side note, Ted, and now you can stop recording if you want to, but I really do think that one of the things I've been trying to get lawyers to do is to also just have more meaningful conversations with judges ahead of voir dire process about what, talking to them about the biases they see as going to be especially important in making peremptory challenges and cause challenges in the case. So you condition the judge ahead of time. You have a meaningful conversation with them about the voir dire process, about what you think you need in terms of time, in terms of effort to do it, and why you need it, so that they're not just slamming you through a 20-minute voir dire. And so the more I think attorneys can have these conversations with judges, which give them good substantive reasons as to why they're asking the questions they are, and also to avoid that. The thing that judges hate, obviously, are all this indoctrination they hear in voir dire. And so if you can convince the judge, no, I'm really trying to find out what are those things that are going to affect the ability of a jury to be fair and impartial, I think you're going to have more reasonable judges who are going to give you a little bit of time to do that.
That's why we do the motions in limine.
Yep.
And why I make them write them, because I completely agree with you.
Yeah.
Good side note. I'm glad I didn't click off the recording.
Yeah.
I'm going to call you back on the landline.
All right. Sounds good.
Okay. Thanks. Talk to you shortly
Right.
if I can figure this out.